Good morning once again, Namibia, and welcome back to the Government Information Center, this time around for a Cabinet Committee briefing session. Now, this is a national platform that is initiated by the Government of the Republic of Namibia, emanating from the Government Communication Strategy approved by Cabinet and rolled out by the Ministry of ICT. Now, the platform is initiated to serve as a conduit for transmitting information on government projects, programs, policy formulations, and advancement, but also strategic implementations within the respective OMAs. Now, the aim for this platform is also to fast-track information dissemination across all organs of government to the general public. For this morning's edition, I am your host, Heleni Felepo-Samunyela, and I'm delighted to introduce to you the Honorable Minister of Justice, Honorable Yvonne Dausep, to update the Namibian nation on the Ministry of Justice operational and legislative update. Honorable Minister, once again, good morning and welcome to the GIC. You may take the podium.
Thank you so much for the opportunity. It has been 5 months since our last update, and a lot has been happening since. It is always a pleasure to share with the Namibian public why we are doing what we do and how we are faring in terms of our key deliverables, which were aptly set out in my appointment letter of 21 March 2020. Our focus is always to uphold our mandate of ensuring access to justice for all Namibians and to provide people-centered legal services. This we do through our key service centers, namely legal aid, community courts, Master of the High Court, and responsive and adaptable law reform initiatives. Over the past few months, we have inaugurated additional courts, including a landmark first for Namibia. We've strengthened our support for community courts and continue to review our efforts on service delivery and meeting Namibia's human rights obligations. Our commitment is to contribute towards a people-centered justice system that reflects the constitutionally entrenched aspirations of life, liberty, dignity, justice, and the pursuit of happiness. We understand that the proper administration of justice dictates that the system must be fair, accessible, and inclusive. Guided by the principles of integrity, transparency, and accountability, we strive to deliver services that meet the needs of all Namibians while promoting the rule of law and a culture of human rights. As is customary, it is important to take every opportunity to reiterate the mandate of the ministry and its core responsibilities, which are central to our service delivery. The Ministry of Justice fulfills its functions through several key service centers, including legal aid, which provides state-funded legal representation to those who cannot afford a lawyer, legislative drafting, which translates policy for all government offices, ministries, and agencies into law, the Law Reform Policy and Legislation Directorate, which acts as a secretariat to the Law Reform and Development Commission and drafting policies and legislation for the ministry, who recently was instrumental in assisting with the electoral amendment and the research thereof. The Directorate responsible for legal services, which facilitates international legal cooperation with other countries, the United Nations, and its agencies, the Commonwealth, the African Union, and SADC. The Master of the High Court, the public's favorite, supervising the administration of deceased estates, insolvencies, trusts, the Guardians Fund, and curatorships. And finally, and our latest and newest directorate, community courts, which we established given the importance of these courts in ensuring access to justice at the community level through 37 courts established across the country. The truest form of bringing the law closest to the people and where restorative justice is the currency. We have also recently increased the annual subvention from 120,000 Namibian dollars per community court to 250,000 Namibian dollars per community court, and where the need for additional support is expressed by the community courts, we also provide such additional material support. on specific aspects of activities we've undertaken since our last update, on law reform, the Dissolution of Marriages Act number 10 of 2024. The recently enacted legislation reforming divorce laws in Namibia marks a significant milestone in ensuring fair and equitable treatment for all parties involved in divorce proceedings. This new law, which aims to consolidate and reform the legal framework concerning divorces related to civil marriages, has come a long way since its initial undertaking in 2001. The Act awaits the formulation of the rules of the Magistrates and High Court and training of magistrates for it to become operational. We don't foresee that this will be prolonged longer than is necessary. The amendment of the Legal Aid Act 29 of 1990 and the repeal of the Administration of Estates Act of 1965. The Ministry of Justice has prioritized the amendment of the Legal Aid Act 29 of 1990 and the repeal of the Administration of Estates Act number 66 of 1965 to address critical gaps in service delivery. The Legal Aid Act specifically has remained unchanged since its inception and has become inadequate in light of the significant rise in legal aid applications from fewer than 1,000 annually in 1990 to approximately 10,000 in recent years, necessitating reforms to ensure efficient and equitable access to justice. Similarly, the Administration of Estates Act, which governs the administration of deceased estates, insolvencies, and trust, is outdated and fails to reflect current social realities. Both proposals have been approved in principle by Cabinet, and with the Legal Aid Amendment Bill now proceeding to the Cabinet Committee on Legislation. These efforts, guided by the Ministry's Committee for Strategic Reform, Process Reengineering, and Customer Care, aim to modernize both frameworks and enhance service delivery to better serve the Namibian people. This is our effort to use the law as a tool to enhance social justice. We certainly hope to table the Legal Aid Act amendment with the National Assembly resumption in February 2025. The Ministry has also obtained Cabinet approval to introduce an Estates Practitioners Bill to regulate the professional conduct, qualifications, and duties of those who manage and administer estates, such as executors. There is a draft ready for targeted consultations and a fast-tracked process to have it also tabled between February and March 2025, given its significance and aim to protect the public against professional negligence and maladministration. Furthermore, the Ministry of Justice has finalized and are advancing the following draft laws through the lawmaking process, namely the Child Justice Bill, the Ombudsman Bill, which has been certified and ready for tabling, the Prevention and Combating of Torture Bill, previously tabled in the National Assembly, the Judiciary Bill, which we hope to table in between February and March 2025, and importantly, the Small Claims Court Bill, which will be submitted for Cabinet approval at the next deliberative meeting still in this year. Since our last update, each of these bills has advanced to the next stages in legislative process, demonstrating significant progress towards their completion. Institutional frameworks. Courts play a pivotal role in upholding the rule of law, ensuring the administration of justice, and recognizing their importance. The Ministry of Justice has made significant strides in the past half year by inaugurating new courts to improve access to justice across Namibia. Environmental Crimes Court. On 19 August 2024, the Environmental Crimes Court was inaugurated in Otjiwarongo, Otjozondjupa region, the first of its kind in Namibia. This specialized court underscores Namibia's commitment to combating environmental crimes in line with its improved performance on the Financial Action Task Force effectiveness rating. The court enables the swift prosecution of offenses such as wildlife trafficking, illegal logging, and pollution, aligning with national and international efforts to safeguard the environment. The Ngwaganqas Periodical Court, the first court in this district, was inaugurated on 13 September 2024 in Ngwaganqas, Hartab region. This court enhances access to justice for residents in remote areas, reducing travel burdens and ensuring timely resolution of legal disputes within the communities. The Katima Mulilo Magistrates Court. On 17 September 2024, the Katima Mulilo Magistrates Court was inaugurated in the Zambezi region, serving as a centralized one-stop state-of-the-art facility for resolving legal matters. The sittings of the Environmental Crimes Court and Katima Mulilo Magistrates Court have been gazetted and proceedings are already underway. The ministry remains committed to advancing the development of more courts, further bringing justice closer to the people and addressing the unique needs of various communities, including our efforts to decongest courts and increase the finalization rates in the court system. The Satellite Office for the Master of the High Court. The renovation of the Satellite Office for the Master of the High Court in Marula, Katutura is underway, and projections are that that office will open in February-March 2025 next year. The establishment of the gender-based violence courts in Keetmanshoop is still in progress and will continue as planned. The procurement process for the Nkurenkuru Magistrates Court is underway with the project expected to commence in 2025. The Ministry of Justice has undertaken a significant project to renovate and refurbish the Justicia building, which is the headquarters of the Ministry of Justice. This process was carried out in a manner that did not disrupt daily operations. The Ministry of Justice headquarters is currently housed in the old F&B building known as Talas Building opposite Nampost Independence Avenue. In other matters, we have also recently hosted a legal aid regional workshop. The ministry was honored to host the legal aid regional workshop in Windhoek, a significant event co-organized with the United Nations Office on Drugs and Crime. The workshop brought together legal professionals, policy makers, and civil society organizations from 14 Southern African countries, including UNODC representatives from Brazil and China, to discuss and exchange ideas on improving legal aid services across the region. Importantly, this workshop served as a platform for enhancing Namibia's legal aid system, which has immense potential to provide accessible and equitable legal support to many particularly vulnerable groups. The discussions highlighted the role of legal aid as not only a constitutional right, but also as a fundamental pillar of justice. For our human rights obligations, Namibia recently defended its torture report before the United Nations Committee Against Torture in Geneva on 30 to 31 October 2024. This event marked a significant moment in Namibia's commitment to upholding the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment, which it ratified as part of its international obligations. The review involved a public dialogue with the committee where Namibia's delegation addressed questions regarding the country's implementation of the convention, as well as measures taken to combat torture and ill treatment in the country. Namibia is scheduled to appear before the International Court of Justice on 9 December 2024 to present its submission on climate change. where one of our own, Dr. Njoti Dweyema, will be the lead counsel, assisted by others. This appearance is part of ongoing public hearings scheduled from 2 to 13 December 2024, where various nations will present their cases related to international law and climate issues. Namibia's presentation is significant as it brings attention to the legal aspects of climate change, further positioning the country within the global dialogue on environmental protection and international climate governance. Other highlights, as I conclude, is that the Ministry of Justice is participating in the NDP6 formulation that is underway. We have also finalized our draft strategic plan for 2025 to 2030, which is built on the proposed pillars for NDP6 and is anchored on developing a culture of justice that is people-centered. The Master of the High Court is doing well in complying with the grey listing requirements in terms of collection of beneficial ownership information and has been identified as a leader in the region. Importantly, efforts are made to improve the completion times, address public complaints, and to accelerate the law reform process that will improve service delivery in the area of administration of deceased estates. I thank you.
Thank you so much, Honourable Minister, for delivering that comprehensive report in as far as the Namibian legal landscape is concerned, and ensuring that the ministry is actually doing so much behind there in the background to ensure that we Namibians are taken care of as far as the legal landscape is concerned. Thank you so much, Honourable Minister. You can now join me on stage.
Thank you.
Right. Now, Namibia, I'm inviting you to be part of this conversation by following the discussion on our social media platform, where we are currently streaming this show live. On Facebook, we are at Ministry of Information and Communications Technology, or alternatively, you can also stream us live on our YouTube channel, and our handle there is MICT Namibia. Be part of the conversation. Add your voice to the conversation by posting your questions in the comment sections on our social media platforms. Now, Honourable Minister, what I've deduced from your update earlier as you were addressing us, I wanted to find out, I understand that there are 37 courts, community courts that are established across the country. Where are these footprints? Can we confidently say they are in every one of the 14 regions?
I can confidently say that all 14 regions have, whether you go to the north, in fact, in the north, all of the traditional authorities have community courts. If you go to the south, if you go to the Omaheke region, whichever region you go to, there would be a footprint of a community court. Community courts are important because, firstly, they are among the people. And then secondly, that's the one court, and I'm not saying the other courts don't provide restorative justice,
Absolutely.
but that's the one court where the principle of restorative justice is real. When you commit a particular crime, and community courts focused on what we would consider traditional crimes, but also they focus a little bit more on petty crimes.
Right.
You know, when somebody's swearing at you, when people have disagreements among in the community, or issues that pertain to traditional issues.
Absolutely.
Whether or not members of that particular society have an interpretation of what their culture is, that kind of interpretation can also be brought to the community court for its consideration.
Okay.
So community courts are important for us, and that's why we created a directorate specifically that will be focusing on community courts, because we believe that if we are talking about access to justice, in the end, if you have a functioning, well-supported, well-resourced community court, most people will
make an effort to resolve their disputes at that level.
Right.
And there will be no need for people to come to the magistrates' courts, come to town to try and resolve their issues. So, so that was the first thing we did, to create a directorate. Second thing we did, and we'll continue to do that, is we increased the amount of money that we give to community courts annually from 120,000 to 250,000.
Okay.
We believe that over the next few years, there will probably be an increment over time as the needs arise, because community courts are also platforms for employment creation.
Absolutely.
You know, and it also provides an opportunity for the community to be part of an important function. The solicitors and the judges on those community courts are important functionaries of the courts, and people have very high regard for them.
Okay. Now, Honorable Minister, as you were busy responding to this question, I couldn't help but wonder. Of course, there must have been challenges establishing these 37 courts across the country. Talk to us about some of the challenges that you've encountered in establishing some of these community courts.
So the first thing that we did as a government in 2003 is to pass a law that specifically deals with community courts. And I suppose the biggest challenge would have been capacity. You know, do people understand what are the unique practices and customs in that particular area?
Right.
So that, because remember, law, you need to know the law. What are you violating? What law are you violating?
Absolutely.
For you to be charged with a crime? And so I think maybe the challenge would have been initially, what are the kinds of crimes that we should allow to be considered at the level of the community court? There is still a bit of a challenge there. You know, sometimes, because you know how communities operate, there is concepts such as wiping of tears. And so there was a threat to, a challenge about people feeling, particularly those that have been accused of having committed a crime, feeling that they are being punished twice. Because in the community, if you, for example, committed a crime such as theft, is fairly straightforward, because with theft, if you have committed theft, you are expected, the court would make a ruling that says you are expected to give the person back what they have lost.
Right.
And that's why it's restorative. But I think it's the capacity of those that would be serving in that role. The other would have been people not understanding what types of cases should come to the community court. And I want to clarify for the viewers that, for example, crimes such as, you know, state crimes, such as rape and murder and major robberies with aggravating circumstances, these are not cases for community courts. The Prosecutor General of Namibia has the sole responsibility and authority to prosecute crimes against the public, crimes against the state. And I think initially there may have been some confusion over the years for people to understand that it's not all cases that can go to community courts. But also, I think it's understanding that process, at the cultural processes at the traditional level, do not interfere or take away the criminal part that the Prosecutor General plays in prosecuting crimes. So those would be some of the highlights. I do think also the relationship between, for example, the role of the police under the Community Courts Act, the role of the magistrates court as an appeal court, for example, that's challenging, because we are talking about a traditional court, if you'd like, and community courts are supposed to complete all their processes at that level. And that's why, as a ministry, we've taken the decision already a couple of years ago to reform the community courts legislation, so that we can become a bit more responsive, so that we can take into account some of those challenges and respond to them, and also ensure that the communities, the traditional communities that are served by this legislation, takes into account the unique circumstances of those communities that we serve.
Okay. Now, Honorable Minister, I would like to know, For instance, hypothetically speaking, a community member is, let's say, aggrieved of a certain crime or offense, and the community member would now want to go through a community court. Can this community member approach both the community court and escalate to the high court, or is it in particular certain offenses can only be charged at the community court and not at the high court?
At the moment, members of the community have a choice. There is no obligation for a member of the community to be subjected only to the community court.
Okay.
If a particular matter warrants that a member of that particular community decides to approach the magistrate's court, they have a right to do so. Because I think, the intention is not to restrict the rights that members of our society have under the Constitution. What we do want to address, though, with the reforms that we are proposing, is to isolate cases that will strictly be dealt with by community courts. Because remember, the intention with capacitating and enhancing the profile of the community courts is intended to decongest the court roles at the level of the magistrates court and at the level of the high court. So if we can have properly functioning courts, and I know that people are, previously it was, and that's why we have a law. People used to think of traditional courts as kangaroo courts. They don't consider human rights issues and so forth. But I think we have the kind of training that we provide as a ministry also teaches those solicitors and judges to take into account that we live in a constitutional democracy, that we have that even accused persons have certain rights and that they should be treated a certain way. And I think we need to build that capacity to develop a culture.
Okay.
That people take into account the cultural aspects, but also take into account the human rights aspects when people are accused of crimes.
Absolutely. Now, Honourable Minister, you've also mentioned about child justice and judiciary bills and small courts bill. Can you briefly just highlight on what these bills entail?
So let me start with what I consider to be an extremely important one, and that's the small claims court bill.
Yes.
It's been under discussion for quite a while because, when you're talking about small claims, we want people to not having to rely on a lawyer to resolve their disputes.
Right.
There are some small disputes that two individuals can resolve between
Amicably.
themselves or even among themselves. So the intention with the small claims court is to create a platform that is accessible, that is inexpensive, and that allows people in a quick kind of fashion resolve their disputes.
Okay.
And really part of that small claims court is for us to increase the opportunities for access to justice. Can you imagine if we have a fully functional, properly managed community court and we have a properly managed small claims court that addresses claims between 1 to 25,000 Namibian dollars, where people can go and resolve their issues among themselves.
Right.
And there's only a person that is a mediator, so to speak, without having to spend too much money. And then you have your magistrates courts, and you have your high court, and then your Supreme Court. If all those courts function properly, we shouldn't have a problem of a backlog of
yes.
cases.
Yes.
We shouldn't have cases taking too long to be resolved.
Right.
So that's the one. So small claims courts are intended to do that.
Okay.
The second, in fact, work on the small claims court already started with the Law Reform and Development Commission many years ago. So that's priority for us. We hope to finalize it as quickly as possible. I will submit a cabinet submission at the next deliberative in 2 weeks' time for principal approval. And then the judiciary bill only deals with an aspect. In 2015, the judiciary was removed from the Ministry of Justice.
Right.
So that we could reaffirm the independence of the judiciary, so that it's not under the executive, as it were, even though we didn't have challenges even about how it was administered then. But our, passing a law in 2015 to extricate the judiciary from the ministry was intended to buttress that principle of separation of powers and the independence of the judiciary. But there was an element that remained in that law with us, and that was the element of capital projects, infrastructure development. So we were still responsible for not establishing, but building courts and those kinds of things. What we are doing with that amendment, it's a small amendment, is we are returning that responsibility back to the judiciary. Because, capital projects is very, very intensive, and we wanted to open up, create space for our executive director who services so many principals to have a little bit of room to do other things within the ministry. And I think also it was important for the judiciary to take that responsibility themselves.
Right.
The ministry and the Minister of Justice still continues to play a role to provide support to the judiciary in the National Assembly, in Cabinet, and so forth. And there will still be consultations between the ministry and the judiciary when it comes to establishing courts and so forth. So that relationship will not change, but the responsibility would be shifted back to them.
Okay.
Child justice, again, very important. It has to do with children in conflict with the law. And we wanted to create an environment where, despite the fact that our children would be accused of a crime, that it's still done in a manner that supports them, that rehabilitates them, that doesn't punish them, that doesn't make them criminals, because children still have an opportunity to change their ways.
Right.
And I think as a society we have a responsibility to continue to protect our children. And so the child justice, in other jurisdictions it's called juvenile justice, is intended to govern how do we deal with children in conflict with the law.
Okay. Thank you, Honourable Minister. And then I think you've also mentioned something about the question is, how does the Ministry of Justice collaborate with other government ministries and agencies to ensure effective implementation then of legal reforms?
So not only do we collaborate in the form that various staff members from the ministry are often seconded to participate, sometimes serve in various ministries. I mean, the Ministry of Trade on the consumer legislation has benefited from the ministry staff being seconded. Currently, one of our staff members is seconded to provide support on cybersecurity from the Law Reform and Development Commission, also on the green hydrogen space, the law reform activities there. So it is very common for our staff members to be seconded to various ministries, offices, and agencies. That's one. But the other collaboration, and maybe a big collaboration, is the fact that the Law Reform and Development Commission is available to provide policy and research support to ministries. Once they've asked us, that directorate is the commission and the directorate are available to provide that support. We are also responsible for legislative drafting, and all bills across the country, are channeled firstly through the Cabinet Committee on Legislation, which I am the chairperson, and then secondly, it goes to the legislative drafting directorate, and there they also often are asked to provide support on layman's drafts before they themselves have to spend a lot of time fixing and making sure that the laws that are going to the National Assembly are in the correct format, are using the right language, and so forth. So it's almost, the Ministry of Justice, I almost want to say, is a portal of activity for all offices, ministries, and agencies.
Okay. Now, Honourable Minister, as far as staff capacity is concerned, what is the ministry, or is the Ministry of Justice perhaps facing any challenges with staffing, and what measures are being taken to ensure that the capacity of legal personnel in the country is strengthened?
We have major challenges. Some of the problems that we're experiencing in our key ministries or service centers, as it were, in the Directorate of Legal Aid, the Directorate, administratively we provide support to them, prosecution, and also the Master of the High Court, the key ones. I think there is a need for us to increase the capacity, and we've done so quite significantly over the past few months. I believe there was 20 plus staff prosecutors were appointed just in the past 5-6 months.
Okay.
And it was the case even for magistrates. At the moment, despite the fact that there is an Office of the Judiciary, the Minister of Justice is involved in the appointment. At least I sign off the letter of appointment of magistrates, and I've seen an increase in the number of magistrates.
Okay.
Now, so human resource capacity is a challenge, but what we have done with some of the reforms that we have now, the idea is first to see how can we improve the language of the legislation that establishes and governs the various directorates that we have in the country, in the ministry, such as legal aid and the Master of the High Court. And then we've also identified, for example, in the Master of the High Court, we realized that there's a master, and there are only two, at the moment, there are 3 deputy masters, one that was recently appointed for trusts. And we realized that even though we have a lateral, a nice setup at the bottom, the people who approve at the top were not enough.
Right.
And so you sometimes get a little bit of a bottleneck up there. And to address that, we've asked the Public Service Commission to improve, to give us more vacancies. And so we will, I think every year, I'm sure, we will have deputy masters. At the moment we have 3. We believe that they should be at least 5 or 6.
Okay.
We also, with the amendment of the administration of estates legislation, we are hoping that we would have deputy masters in various parts, and it will be decentralized. That will also help with the approval process. At the moment, we have only one other office in Oshakati, and then the main work, most of the work happens in Windhoek, but we have now agreed, and it was part of my report, we will have a satellite office in Katutura, in Marula.
Right.
And we
taking
hope,
the service to the
yes,
people.
taking the service to the people, so that people don't always have to worry about tax money if they have to report a deceased estate. So I think it's important developments. It's incremental. It's small steps that we're taking, but I think the recognition on our part is, if we have more people in the various service centers of ours, we believe that our service delivery will be faster. It will be a bit more, it will certainly be more efficient. And also we will introduce aspects of technology. Some of the, for example, in legal aid, some of the applications would now be done electronically.
Right.
You'll be sent an SMS, you complete the form on a computer, electronically, and you don't have to wait for that information to reach you at the fastest time. The other thing about that technology, it will also be introduced in the court systems. We've certainly done so in Katima Mulilo with that court. State of the art, we can do video. People can now present their evidence virtually. If they are not able to make it into the court, there's some protection mechanisms for children. So there's a lot happening in terms of us creating capacity, both electronic capacity but also human resource capacity. We continue to engage the Public Service Commission where we see a need so that we can open up the establishment, which has been very, very restrictive. We have relief magistrates, we have relief prosecutors, I'm sure, but also I'm sure we are one of the best ministries when it comes to internships. We have a lot of interns, some of them that we convert into joining the ministry full-time.
Okay. No, it's quite commendable to note that the ministry has incorporated technology to improve the legal services and streamline operations, especially with regards to case management and public access of legal information. It is very highly commendable, especially with what you've done with your Katima office, as earlier mentioned.
Thank you.
Honourable Minister, we have run out of time and we've come to the end of this discussion this morning. Thank you so much for taking out time away from your busy schedule to come and update the Namibian nation on what operational and legislative matters that the ministry has implemented since 6 months ago, as you've rightfully mentioned. Thank you so much for making time to come and educate us this morning.
Thank you very much. We also have very well functioning social media platforms where the members of the public can follow us, and if they have any concerns, if they have any questions, they can also raise those questions on those platforms. We are public servants, so it is always a pleasure to speak to the Namibian public.
Thank you so much.
Thank you very much.
There you've heard it from the Honourable Minister. Thank you so much, Namibia, for tuning in to this morning's Cabinet Committee briefing session with me, Heleni Felepe-Samunyela. From myself and the entire GIC production crew, until tomorrow, take care.